Please be seated. The court is now in session. Based on our changed schedule, and as all parties have been informed, the Chamber will conduct document hearing today related to case 002/01. As we all know, last week the accused had some health issues that needed to be treated urgently at the hospital. The schedule to hear the testimonies of certain witnesses have been adjourned. And all parties have been informed of the change scheduled. And we will conduct a document hearing today. The memo has been sent by the trial chamber dated 17 April 2013 regarding the rescheduling and the document hearing today and tomorrow, that is the 21st and 22nd of January 2013. That is document E223/3, and we had two main purposes in the memo. That is, first, the discussion of the remaining documents that have not yet put for discussion before the chamber, and second, the submission or presentation of documents that are deemed important to be discussed before this chamber, that is related to case 002/01. And before we conduct the document hearing, the greffier, Mr. Evidentiary, could you report the attendance of the parties and individuals to today's proceeding? Evidentiary, Mr. President, for today's hearing, all parties to this case are present, except the accused, Ieng Sari, who is present in the holding cell downstairs due to his health reason. The accused Noon Chi and Khieu Sampon are absent due to health reasons. However, they submitted the letter of waiver on document hearing to the chamber. That is document E258/2 and 223/4. Thank you. President, thank you, Mr. Evidentiary. And before we proceed with the document hearing, pursuant to our memo dated 18 January 2013, in fact, the document hearing had been scheduled from the 18th to 21st. That is document E236/4. However, due to the change schedule and the health concern of the accused, the chamber cannot hear the testimony of certain witnesses. We decided to move the hearing of the documents to this week. Two of the accused, that is Noon Chi and Khieu Sampon, although they are being treated at a hospital, they are mentally fit, and they submitted their waivers in writing to the chamber on Friday last week. For that reason, the chamber will proceed with the document hearing, and before that, we will want to ask the counsels of Khieu Sampon and Nuon Chea if there is any change to the conditions of your clients regarding the waiver of their presence in the document hearing, and it's for Nuon Chea's defense first.
Good morning, Mr. President, Your Honours. There is no change. The client has given us a waiver to go ahead with the document proceedings. The health situation is deteriorating, though, so that's troublesome. But there's no change in respect to the waiver issue.
Thank you. And the defense counsel for Khieu Sampon, you may proceed.
Thank you, Mr. President. Good morning to you. Good morning to the parties in this chamber. With respect to Mr. Khieu Sampon, the situation remains unchanged. We went to see him and he confirmed his waiver for the debate on the question of documents. I also know that he's very weak and very tired. We are waiting for fresh information from the medical team, but for the documents hearing, he has indeed granted his waiver, and that remains valid.
President, thank you for your latest update regarding your client's health and the waiver of your client's presence in the document hearing today. The chamber, however, would like to inform the two defense parties, Nuon Chea and Khieu Sampon, that we will give the opportunity to the two accused for their remarks on the documents to be submitted for discussion before this chamber in due course, if they wish to do so. As indicated in our memo, that is E258, we will hear the discussion and arguments regarding the remaining documents and the new kinds of documents to be submitted to be placed in case 002/01. Those documents were related and referenced in the closing order regarding the Tulpu killing site and the forced movement of the population. That is the paragraph 205, 209, 1115. My apology, that is 205, 209, 698, 2711, 975 to 977, 1115, 1191 to 93, and 1373 to 75, 1377 to 79, and 1781, 1415 to 1418, 1423 to 1425. And in addition, the Chamber will hear the arguments regarding the 48 documents proposed to be submitted by the OCP before this Chamber. Those documents are not relevant to the killing site at Tulputray and the displacement of people, as well as other documents by the OCP related to Tulputray killing site. Other parties who have not submitted to have documents placed before this Chamber the purpose of the document hearing is not for the new discussion or argument regarding the acceptability of those documents or admissibility of those documents, as the Chamber indicated previously. Many of the documents have been raised and presumed to be submitted before this document, that is the E3 type document, as they are of importance to this case. However, the public cannot be informed of all the contents of the E3 type documents, and the documents that have already been recognized by the Chamber as submitted by various parties during the proceedings. It is important for the Chamber to know the exact numbers proposed by the parties, including both the inculpatory and exculpatory documents that have not yet been discussed before this Chamber. The discussion is based on the documents deemed important by various parties in order to ascertain the truth related to case 002/01, related to the facts that have not yet been discussed before this Chamber, and the displacement of people in the first phase, and the killing site of Tulputray, the military structure, and the movement of people during the second phase. We would like to inquire from the prosecution what is the proposal to be made by the prosecution?
Thank you. Good morning, Mr. President. Good morning to the bench and to all of the parties and to the public here. What we are in fact proposing is talking exclusively about questions of admissibility. The documents in Annex 1, 2A, 2B and 2C of a response that we had given the Chamber in November 2012. It's E223/31.1, that's Annex 1. I repeat, E223/2/1.2. Annex 2A is E223/2/1.2, and 2B and 2C are roughly the same references, but which end in 3 and 4. So E223/2/1.3, and the fourth is point 4. In fact, on the 23rd of November 2012, Mr. President, we were the only ones to respond to your request to inform you about which additional documents we wanted to bring before the Chamber concerning forced transfers and Tulputray. That's the table in Annex 2A, 2B and 2C. In other words, 94 documents that are distributed over 3 tables. The first forced transfer, the second forced transfer, and the third one being Tulputray. In addition to that, in the response to the Chamber, we also took an initiative to include an Annex 1, which concerned 48 documents, which, as we see it, are the only documents that hitherto have not received adversarial debate about their admissibility. I don't think, unless the Chamber so requests, that it will be useful for me to explain how we reached this conclusion about the 48 documents, but all of the other documents have already been granted hearings in January, February and March of 2012 and are essentially contained in Annexes 1 to 11 and 14 to 20 of document, if I can just find it, E109/4 of 22 July 2011 from the OCP. Now, there was an exchange of emails last week on the question of whether we were talking about 48 documents or 500, and in an email to the senior legal officer, we did establish that the 444 documents that may be included in these ideas in fact belong to Annexes 1 to 11 and 14 to 20, and they've already been discussed in adversarial debate. If necessary, I can come back to this issue and explain a little bit more in detail, but to come back to Annex 1 and the 48 documents, that in fact includes 2 documents that are contained in the closing order footnotes, which concern forced transfer and Tolbo-Shrey. Why are there only 2? That's simply because we compared one-to-one all of the documents that are contained in the footnotes for the paragraphs concerned in the closing order, and all of the documents, with the exception of 2, have either already received their E3 code after discussions on Annexes 1 to 11 and 14 to 20 held last year, or were at the time considered to be new documents, but the title of new is not entirely correct, and have already been debated, even if decisions have not been taken about them as yet. Once again, Mr. President, I can go into greater detail if you so wish, but just to say how we intend to proceed with respect to Annex 1, apart from the 2 documents from the footnotes, it includes 6 documents that were proposed by the co-prosecutors, 3 proposed by the civil party co-lawyers, and consequently, with respect to those documents, it would be logical for the defence to begin to see if they have any objections to level, and as for the 114 other documents which we have proposed to add, they concern forced transfer and Tolbo-Shrey. Coming back to Annex 1, on the table we also included a certain number of documents that were proposed by the defence teams and which haven't yet been subjected to adversarial debate in this chamber. This includes 4 documents that were proposed by the Engsari defence team, and 21, if I am correct, proposed by the Kyosampan team, and in that respect I will point out already that out of the 21 documents the OCP will be objecting to 4, and the remainder of the documents were proposed by the Nunchea team, and there are 11 in that respect, to which the co-prosecutors will make again 4 objections. How should we proceed? I believe that since the co-prosecutors have proposed the maximum number of documents in the annex, I believe that it should be the defence teams that should tell us first what objections they encounter in these documents, and then we can respond, and in turn we can make our points and about the 8 objections to which the defence can then respond itself. That's how I propose that we proceed, Mr. President, and if we want to be entirely systematic, perhaps we should start with the objections concerning the 48 documents and then move on to the 80 or so other ones proposed by the co-prosecutors. That's how I see it, Mr. President, but of course I'm entirely at your disposal if you wish to proceed in a different manner. Thank you very much.
The President. Counsel, you may proceed.
Merci, Monsieur le Président.
Thank you, Mr. President. Very briefly, I would like to clarify the position of our team regarding this hearing. As we've had occasion to explain in various email exchanges, the circumstances of this hearing, which comes a lot earlier than expected, is that the preparations would not have been the same if this hearing had been held in February. We've stated that we encountered difficulties in trying to cross-check the list as proposed by the co-prosecutors. We are not being defiant here, but no one is immune to error. Under these conditions, we are satisfied with the indications given by the senior legal officer that today's hearing cannot put an end to discussions of these documents, subject to allowing the defense and others to revisit the issue of the 48 documents identified by the co-prosecutors as documents that still have to be discussed regarding admissibility. This is an important point because I do not want anyone to say that we did not raise the issue of admissibility at this stage regarding documents which, in our view, have already been presented before the Chamber. On this point, let me point out the issue raised by the co-prosecutor himself, that initially we had talked of 500 documents, that the co-prosecutors reduced them to 48 documents because they were of the view that some of the documents had already been discussed alongside Annexes 1 to 14. To further shed light on what I'm saying, let me recall that in decision E72/5, the Chamber had pointed out that certain new documents could be discussed later, and that the record of proceedings E1/4850, it had been pointed out that documents in Annexes 6 to 20 were new documents on which discussions were going to be held. It appears that I'm going too fast. Let me repeat what I'm saying at the hearing, during which the record E1/47.1, my learned colleague has said that some documents in Annexes 6 to 20 were new documents with respect to which discussions had been deferred because we have not had a chance to cross-check each and every one of those documents in view of today's hearings in order to make all objections on the part of Kiki Sampan. We want to point this out to the Chamber. This brings me to my second point. In light of your decision E187/1 of the 3rd of December 2012, in which you stated the conditions under which we can discuss the admissibility of certain documents, it would appear that your approach is completely different from that of other international tribunals that adopt a broader perspective with regard to admissibility, and you place the discussions solely in terms of probative value. We want to point this out at this juncture because it should be borne in mind by all the parties to these proceedings. This means that after the presentation of all evidence, we should have an opportunity, regardless of the manner in which we should have such a discussion. We should discuss the probative value so that in your deliberations you may bear in mind the positions of all the parties regarding the probative value of all these documents. We cannot avoid such discussions in this trial, given the weight you attach to evidence in your deliberations, and we, the Kyo Sampan team, would like to point this out today. I thank you, Mr. President.
The President. Thank you. Now, the floor is given to the prosecution to present the 48 documents sought by the prosecutor. The President. Following the deliberation of members of the bench, and to make it precisely clear, I hand over to Judge Sylvia Cartwright to advise the parties in relation to the hearing that we are commencing on. I now hand over to Judge Cartwright.
Yes, thank you, President. The Chamber has agreed that the best way to proceed is to focus on the 48 documents that the prosecutors have identified. And the way in which the hearing will now proceed is this. First, the prosecutors will list those documents for the sake of the record, but make no further comment on them. Then the floor will be given to the defence, who will, where each team will have the opportunity to object to any of those 48 documents, and any for which there are no objections will be effectively set to one side. The prosecutors and, if necessary, the lead co-lawyers will then have the opportunity to respond to the objections raised by any of the three defence counsel. So for this portion of the document hearing, we are focusing only on the 48 documents identified by the prosecutors. President, I hope that encapsulates the comments you had. Thank you.
The President. Thank you, Judge. Now I hand over to the prosecutors.
Merci, Monsieur le Président.
Thank you, Mr. President. Let me add one point to what Judge Cartwright has said. Let me remind all of us that there will be 8 objections made by the co-prosecutors. So 8 objections to the 48 documents. So this annex does not only have to do with the documents proposed by the co-prosecutors, but by all the parties. And we have 4 objections regarding documents presented by Kyo Sampan, and 4 objections to Noon Chair's statements. We will give the defense the opportunity to respond as the chamber would wish. The first document in the list of 48 is from a footnote in the closing order. It is 3018, and it is document IS 5.3, and it's a confession by Mol Sambat alias Rosnim, dated the 14th of June 1978. So it's IS 5.63, a tool slang confession. The second document is a report on the geographic situation from the co-investigating judges regarding tool post slay, and it's document D125/217, and it is quoted in the closing order in the footnote 3025. Then we have 6 documents which were not proposed by the co-prosecutors. The first is document E216/3.1, this is a collection of different extracts from the handwritten autobiography of Suon Sikun, And this was a motion made by the co-prosecutors 216. The next document is a book by Sambat Tet and Gina Chun. And the number is E152.2. And it is titled Behind the Killing Fields.
Ensuite, il y a la biographie du Camp.
Then we have the biography of Democratic Cambodia of Lon Narit alias Rit. The exhibit number is E3/128. The sixth document on the list, that is Annex 1, is a series of videos of interviews granted by Kyo Sampan. The references are 152.1.1, E152 up to 15253R. These are 54 parts of interviews found between the two numbers. Then we have transcripts of these videos. Transcripts were in writing. The exhibit number is E152.1.1.1 up to E152.1.54.1. The next two documents are also videos. The first is a video produced at the 1998 Kyo Sampan interview. The reference is A190/1/15R. And E190.1.297R. Let me point out to the interpreters that I'm only following the table with reference number E223/2/1.1. If you have it before you, it will be a very useful tool. The next document is a video. These are video excerpts by Tet Sambat, an interview of Non Chia. The reference is E93/7.3R. And there is also a transcript of these excerpts of interviews, and it's E93/7.2R. Regarding the three documents presented by several parties, we retained the book by Raoul-Marc Jenard titled Kyo Sampan et les Khmer Rouges, Kyo Sampan and the Khmer Rouge. And the reference is E109/2.3.1. Then we have a documentary produced by Pochan Natar titled Survive in the Heart of the Khmer Rouge, Madness. And in this regard, let me point out that there was some confusion, because I found a reference in Chamber Decision E90.1. That reference was wrong. The reference was E109/2.1R. And if you would allow me, I would say that this is an error. The reference is E01/E.3R. Perhaps the parties could confirm this subsequently. The next document was proposed both by the civil parties and the co-prosecutors. It is a documentary titled Enemies of the People, and was produced by Ted Sambat and Rob Lemkin. It includes the film itself and 16 clips in the same DVD. The reference is E16.1R. Then we have 4 documents proposed by the Evidentiary defense team. The first is a book by David Chandler titled Transformation in Cambodia, and the reference is D172.6. The next document is a book by Michael Vickery titled Democratic Kampuchea, Themes and Variations. The reference is E190.1.407. E190.1.407. Then we have a book by Milton Osborne titled Sihanouk, Prince of Light, Prince of Darkness, and the reference is E190/2.2. And the last document proposed by the Evidentiary defense team, which we were able to identify, is a press article by Douglas Gillison and Lee Hall. And the title is "177 Released from S21 DCCAM Records Show," and the reference is D22/2052.1, D22/2052.1. And the last document proposed by the Kyo Sampan defense team, the first of these documents is an article titled Bombs Over Cambodia, and it has 2 references. The first is E190/2.6, E190/2.6, I repeat, and the second reference is D153.2.12, I beg your pardon, D153.12. That document was amended in 2009, was updated in 2009. The second document for the Kyo Sampan team is a book by Ben Kiernan, and the reference is E190/2.10. E190/2.10. It is still on the table that was given to us by the Chamber, and this book is titled The U.S. Bombardment of Cambodia, 1969 to 1973, Vietnam Generation. It's a long article dating back to 1997. Then there is a book by Kimo Kiljunen. It is titled Kampuchea Decade for the Genocide, Report of a Finished Inquiry Commission, and the reference is E190/2.11. Then we have a series of international releases from the U.S. Department of State. The first document is E19/2.13. E190/2.13, it is a transcript of a conversation between Nixon and Kissinger dated the 9th of December 2010. Then we have a second document from the State Department, E190/2.14. I beg your pardon, the previous release was produced on the 9th of December 1970, correction by the interpreter. This document, E190/2.14, is a transcript of a conversation between Kissinger and General Haig. Then we have E190/2.16, dated 1975, memorandum of a conversation between Indonesian President Suharto and Ford and Kissinger. The next document from the U.S. State Department is E190/2.15. It is dated the 26th of November, 1975. It is a memorandum of a conversation between Kissinger and Prime Minister Chat Chai of the Foreign Minister of Thailand, Chat Chai. Then we have document E190.1.408. This is a document, notes from the French diplomat, entitled Conversation with Pech Lim Kwon of the 11th of August 1976. This document is from the French Ministry of Foreign Affairs. Then we have a document from the UN General Assembly, E190/2.9, dated the 14th of November 1979. It is a United Nations General Assembly resolution, 34th session, on the situation in Cambodia. Then we have a number of press articles, international press articles. The first of these articles has reference E190/2.17. It is authored by Noam Chomsky, the New York Review of Books, dated the 4th of June 1970. And it is a special issue on Cambodia. Then you have an AFP press titled Arrival of a Laotian Delegation Visiting Cambodia. The reference is E190.1.412. E190.1.412. Then we have a Times article dated the 4th of May 1976. The reference is E190.1.411. E190.1.411. I repeat. And it is titled Defecting Khmer Rouge Helicopter Pilot Tells of Life in Phnom Penh. Then we have a Herald Tribune article of the 11th of May 1976. The reference is E190.1.409. I repeat, E190.1.409. It is titled Escape Because of Khmer Brutality.
Du 17 mai.
Then there's an article from Newsweek from the 17th of May 1976. That's document E190.1.410, entitled Cambodia, Two Views from Inside. The final one of these international media reports is document E190/2.8. E190/2.8. It's an article by William Shawcross, published in the Far East Economic Review, 7th of January 1977, entitled Cambodia. The verdict is guilty on Nixon and Kissinger. After that, there are 4 letters, or 4 testimonies perhaps, on which the co-prosecutors will be objecting, and I will make that objection at a later stage. The first is document E190/2.5. The author is Philippe Julien Gaufre, and the date is the 15th of October 2010. And this is a letter in favour of Kyosampan. The second letter is from Sam Sok. It's dated the 21st of January 2011. Also a letter in favour of Kyosampan, and the reference is E190/2.7. E190/2.7. The third is from Roland Dumas, dated 14th of February 2011, E190/2.18. And the fourth of these testimony letters is from Claude Katz. It was written on the 18th of April 2011 in favour of Mr. Kyosampan, and the code is E190/2.19. There's a further 3 documents submitted by the Kyosampan team, and they are media articles from the Cambodian national media. The first is E190/2.4, and the title of the article by Jean-Paul Degout is Interview with Laurence Pic, June 1984. Then there's an article that came out in the Phnom Penh Post entitled Noam Chomsky Interview by George MacLeod, dated 27th of March 2009, document E190/2.20, E190/2.20, and the third is an article by Ben Kiernan and Taylor Owen called Roots of the US Troubles in Afghanistan, Civilian Bombing Casualties and the Cambodian Precedent, dated 28th of June 2010, document E190/2.12, E190/2.12. Then, to close, there are the 11 documents proposed by the Nunchia team. The first is an article by Stephen Heder, written in 1997, entitled Racism, Marxism, Labeling and Genocide in Ben Kiernan's The Pol Pot Regime. That was written in 1997, as I said, and its code is E131/1/13.3. The second document is a book by Joel Brinkley, or excerpts from said book. The date is 2011. The title is Cambodia's Curse, the Modern History of a Troubled Land. And it's document E131/1/13.12. This is a document on which the co-prosecutors have an objection. There's a report next, E131/1/13.8, E131/1/13.9, 13.8. It's a report by USGAO of the 30th of April 1974 entitled Report to the Subcommittee on Refugees and Escapees, Committee on the Judiciary, United States Senate. After that, there's an international media report by David Shipler, dated 19th of July 1973, which came out in the New York Times, and the title of that is Saigon, prodded by US, lends rise to Cambodia. The document is E131-1/13.6. After that, there's another international media article by Sidney Schanberg, published in the New York Times on the 19th of March 1975, entitled A Cambodian Anniversary Marked Only by Misery. E131-1/13.4. Then there's an article which Angus Deming wrote in Newsweek entitled Phnom Penh New Rulers, published on the 22nd of January 1979, document E131-1/13.7. Then there's another article by Sidney Schanberg which came out in the New York Times on the 26th of February 1975, titled Children Starving in Once Lush Land. That's document E131-1/13.5. After that, there's an April 1990 article by T.D. Allman, published in Vanity Fair, which was entitled Sihanouk's Sideshow. It's document E131-1/13.2. And that again is a document to which we would be making an objection in due course. The last three documents are as follows. The first is a report by the US Senate entitled US Air Operations in Cambodia, April 1973. The report is dated 27th of April 1973 and its document E131-1/13.9. Then there is a PRK Council of Ministers report dated 23rd of August 1986, which concerns the K5 construction plan for fiscal year 1987. Document E131-1/13.11. The co-prosecutors will be making an objection about this document. And last, a report dated the 6th or the 7th of May 1998 concerning a visit to Thailand by Second Prime Minister Hun Sen. Code E131-1/13.10. And that's the fourth of the non-chair documents proposed, to which the co-prosecutors will be making an objection in due course. That brings me to an end, Mr. President, of what I admit is a rather tiresome reading out of the 48 documents subject to debate this morning. Thank you very much, sir.
President, after having heard the identification of the 48 documents sought by and presented by the document, we also notice the intention to object some of the documents by the prosecutors. We would like now to hear the objections raised by the prosecution regarding those documents as presented just then. And after that, the floor will be given to other parties, in particular the defense team. The prosecution, you may proceed with your objections.
Merci, Monsieur.
Thank you, Mr. President. In fact, Annex 1 is not necessarily documents that the co-prosecutors want to enter into evidence, but in fact all of the documents that appear to us to be worthy of debate in this hearing, which is why that there are a certain number in the list that are to be objected to by the co-prosecutors. Let me begin by the first objections to the documents submitted by Kusampan. We don't have any objections to 18 of those, the majority, but there are 4 letters to Kusampan from different individuals, as you have seen. And let me briefly repeat the references. It's E190/2.5, a letter from Philippe Julien Gaufre, dated 15th of October 2010. E190/2.7, a letter from Sam Sok, dated 21st of January 2011. A letter then from Roland Dumas, dated 14th of February 2011, E190/2.18, and finally a letter from Claude Katz, dated 18th of April 2011, which is E190/2.19. These 4 testifying letters should perhaps not be on the list. They have specific difficulties connected with them. There is one question that needs to be clarified in that connection, which is that these testimonies have been put together at the initiative of the Kyosampan defense after the closure of the investigative phase, and they have not been sought by the investigating judges independently. And it seems to us that that unilateral procedure has not been authorized by the Chamber. It was never specified, in fact, to what extent references could be requested from independent parties after the investigation was over. This is not so much testimonies on moral status of the individual concerned, but also it concerns the facts, and they concern the historical context and the functions that were fulfilled by Sampan and actions he undertook. For example, Philippe Julien Gaufre, in his letter, which is a fairly long letter in E190-2.5, advances several hypotheses about the motive for Sampan's succession to Norodom Sihanouk as head of state, or the reasons why Sampan was not eliminated during the course of the regime. And you will find those hypotheses on page 8 of the document in French. It's 00809329. That's in the French version. I haven't had time to look up the other language versions. We believe that the defense could have asked the investigating judges to have heard those people during the investigative stage. That would have presented an awful lot more guarantees, and if they want those written documents to be used and for the Chamber to consider them, then they should, I believe, insist that the people concerned should appear as witnesses. And 3 of those 4 individuals have been placed on E9/11.2, their list of witnesses, namely Roland Dumas, number 6, Julien Gaufre, number 10, and Sam Sok as number 19 on that list. Claude Katz does not appear anywhere, so we'd like to ask the Chamber to adjudicate on that matter. Our position is that those written testimonies, because they were requested at the initiative of the defence and put on the files by them alone, should not stand as having probative value, because they concern the acts of the accused, unless the other parties have a chance to question them if they come to testify. It's just a matter of fairness, really, and respect for the adversarial procedures of this trial. If these are merely letters of support which have regard to the personality of the accused, that is another matter. But given that they also concern facts, then the individuals should be called to testify in person, or else their document should not be taken into account. Perhaps, as I said at the start, I should never have put those 4 letters on my table, and perhaps they should be discussed at a future hearing on different statements by witnesses, whether made before investigating judges, DC-CAM, or whatever. And perhaps these 4 pieces of testimony should be discussed at another hearing. The 4 objections concerning the non-chair defence documents, we contest relevance here, mainly of 4 documents. The first is the book by Joel Brinkley, Cambodia's Curse, The Modern History of a Troubled Land. The reference is E131/1/13.12. What is at issue is a chapter that has been selected by the non-chair defence, which does not concern the facts of which the Chamber is seized. Rather, it is an analysis of a political nature of the current legal and political predicament of Cambodia. And it talks about certain factors that led to the creation of the ECCC itself and the way that it functions. We don't see any direct relevance between Joe Brinkley's writings and substantive proof relating to facts between 1975 and 1979, in particular as refers to the first trial segment that is before us. The second is an article by Allman in Vanity Fair. It's E131/1/13.2. It was published in 1990, and in our estimation it has no particular interest for the dossier before this chamber. It is a political article that concerns the personality of Norodom Sihanouk and Prime Minister Hun Sen, and which recounts a certain number of stories and anecdotes, proven or otherwise, but it has nothing to do with the substance of the matter that is before us. I do not believe that the article will contribute to the elucidation of the truth in this court, and we therefore object to it on the grounds of absence of relevance. The last two documents are E131/1/13.11, which is a report by the PRK Council of Ministers of the 23rd of August 1986 concerning the construction plan for K5 for fiscal year 1987. And I would like to say that in several hearings before this chamber, the bench has stated that matters concerning K5 were not pertinent to this trial, and each time the non-chair defense raised questions on this matter to certain witnesses, there is no, in our view, direct link between the 1986 military plan elaborated to combat the Khmer Rouge and the crimes that were committed during democratic Kampuchea. This document is consequently not relevant for this trial, and suggestions about the utility of such documents for demographic purposes and the number of deaths during the era of democratic Kampuchea has never really been seriously established by the defense. And it does not therefore seem to us that this document provides anything useful to the debate, and the bench has adjudicated on this. Finally, before us, there is report E131/1/13.10, dated 6th or 7th of May 1998. It concerns a visit by second Prime Minister Hun Sen to Thailand and the discussions that ensued. It's a purely political document that relates to a certain context in 1998, which seems not to have any juridical value in this trial. It doesn't concern the facts that are put before us at this juncture, and what is more, I believe that the Chamber's position on this kind of document is pretty clear. With respect to statements that may be contained in this kind of document by political figures, the Chamber has declared that it is independent from any recent or less recent statements by political figures. And the document does not concern facts that concern this tribunal with respect to democratic Kampuchea between 1975 and 1979. So that, therefore, concerning those four documents and as regards the four prior ones I mentioned, are ones upon which we would object. With respect to the non-chair document, the Article 97 relevancy criteria are manifestly not fulfilled, and that is why we do object to them and to the others before this chamber. Thank you.
President, thank you, the co-prosecutor. The time is appropriate for a short break. We will take a 20-minute break and return at 10 to 11. The court is now adjourned.